What's up, everybody? Rob Ferretti here. Welcome to the series where I am representing myself as my own attorney, which is a pro se litigant in a federal litigation against the government. Just want to point out, just in case you're new to this, I am not an attorney. I'm not an engineer. I'm not a planner, not an architect. I am interpreting things that I see. I'm doing my own research. I'm looking at case law. Anything that you see in this video should be treated for entertainment purposes only. I do have to make it watchable, so I do trim some stuff down. It is not my intent to manipulate or misrepresent any material facts in this matter. That being said, enjoy the show. All right, everybody, Rob Ferretti, welcome to episode 5. Now, I'm going to show you in this episode where I realized no matter what I presented, no matter what I did, no matter how I addressed any concerns of my neighbor or the board, they were voting me down. And in doing so and discriminating against me, how ridiculous the resolution of denial was going to end up being. We'll go into the barn ordinance that was then passed to prevent me from coming in from having a barn, and then we will go through and show you what all of these other properties have been effectively approved for, especially the planning board members, and I'm going to say illegally, but let's just say inconsistently, to use language that's less abrasive. You'll start to piece together who belongs or who is in the good old boys club and who is not. So last video you saw me get voted down on my first application. Now, as you know, this process is supposed to be impartial and in public view. That's the whole point, is it's supposed to instill confidence in the public that it's a fair and impartial process. Well, I can prove that it wasn't, and the April 23rd meeting was purely set up to help the planning board justify why they were going to wrongfully deny me. How can I prove that? Well, they carried the meeting over from the March meeting to the April meeting. Now, they had everything that they needed to justify voting on the application. They could have made a condition of approval that they wanted to get rid of the tunnel. They could have made the garage smaller. But this is proven by the fact that they came in and said, like, well, we want to see these changes, but we have to see them. And then Demetrio said, well, wouldn't you have to go back before historic?
I understand, but if he's going to also change it this dramatically, then he's got to come with new blueprints and new
absolutely.
application.
No matter what, if he accepts these suggestions,
The conditions,
it's a whole new...
And they're not actually conditions. They'd have to be new plans drawn
That's
up
what I'm saying.
and show us what he's actually talking about doing.
Yeah.
Based off of which changes?
The suggestion that...
Size of the structure, size of the amount of vehicles you're going to store on the property.
You wouldn't have to go back to the historic board, though, would you?
No, it's not changing how it looks.
Obviously, if I was changing it significantly enough that I would have to revise everything and bring it back for further review, I would have to go back for historic review and approval. Otherwise, I'm not really changing anything. All we're talking about is the size of the garage. It doesn't make any sense. It was just a delay tactic to carry it over to the next meeting so they could make determinations and deliberate behind closed doors. Moving it to the following month was just so that they could set up the denial. And that's exactly what ended up happening. And here's how I can prove that, because when I came in the subsequent meeting, we presented effectively a new application because it's been revised. And that's what we should be focusing on from that point forward. It isn't what I proposed the month before, the previous month, anything like that. The only thing you should be now focusing on is the new application that's before the board. House, 3-car garage. That's it. It can't fit anything more than 3 cars. However, no matter what I put forth, they were going to deny it. And it showed based on the actions of the planning board attorney during that meeting, because you saw the planning board chairman, the planning board vice chairman continually motion for a vote.
We can make a motion on this?
Well, not yet. We have a lot of housekeeping to do first. But Mr. Chairman, I'd like to ask Mr. Poliniak a few questions.
Okay. You want to propose a motion?
Not yet. Let's ask counsel if they have any questions of Mr. Poliniak.
Do I have a motion on this application?
Not yet.
Not yet.
I'd like to ask Mayor Schaefer 2 questions.
Now, this just proves that Ken Dalecki was not acting on behalf of the planning board, at least not at the request of the planning board. If he was, they wouldn't keep motioning to vote. They would be like, all right, we need Ken to do this, this, and this, and then we can make a motion to vote. They kept making a motion to vote. So that means that Ken Dalecki was doing this all on his own accord to justify the denial at this point in time, because he's done everything we've asked. He wanted a 3-car garage. He dropped it to a 3-car garage, so we can't even say the capacity of the garage is a problem anymore, because that variance isn't even on the table. So all we could do is justify the denial of the application, which they already know they're going to deny it. So he was just changing his evidence from a list supportive of the application to a list against the application and justifying why the mayor was given coverage for a 3-car garage and why they were going to therefore deny me the same coverage. That's why he introduced that testimony. That's like mind-boggling, because now the mayor's testifying against the application, supporting why his relief was granted and mine shouldn't be effectively. The mayor shouldn't even be able to vote. He should be now recused. Half of these guys shouldn't be able to vote. According to the municipal land use law, you can't express an opinion on the application. You're no longer objective. So half these guys on the board saying, I don't like it, I think this, I think that, boom, you're now disqualified to vote. You're not able to vote on the application anymore. So there probably weren't even enough people in the room that were quiet throughout the process or didn't instill their opinion that would even be eligible to vote on this first application. However, that's not how it went down. Another way I can show that the vote was predetermined to be a no matter what I did was that the planning board attorney in 2 previous invoices billed me for the proposed conditions that would be attached to an application prior to a vote. And he put them in 1 month, then he revised them for a subsequent month. I don't know what those conditions were. It could have been that I had to not YouTube from the property. It could have been that I had to make the garage smaller. There was some sort of conditions that were drafted and never supplied. He has always presented his conditions on all other applications. This is why public record is great. Before the board motions to vote.
Let me start it off by referring to the conditions that I proposed the board give consideration to that I sent to the board last week. And let me ask, and this includes 1 page of conditions from Mr. Poliniak, listing conditions that should be addressed before building permits are issued.
Any motions?
I'll make a motion to approve the application with the aforementioned conditions.
Do I have a second? I'll second it.
So he prepared these conditions, but didn't present them prior to the vote because he knew the vote was going to be no, so why bother presenting the conditions? You think all that's crazy? Well, just wait till we get to the resolution. And you're going to have to wait, just like I did, because the municipal land use law requires a resolution be produced in 45 days. As I've shown, it took them 83 days to produce my resolution. Why? Well, they wanted to push through this barn ordinance to prevent me from being able to take advantage of the loophole of calling my structure a barn and showing less lot coverage than actually exists on the property. In the same meeting that they voted me down, they put through 2 changes in the ordinance. One was requiring a minimum lot size of 2 acres to be able to call an accessory structure a barn. The second was that they were going to limit the barn allowance from 10% to 5%. And when you rush things, what happens? There are unintended consequences. And that's what we found out here because one of the planning board members, Peter Walsh, had an application pending to build an indoor riding ring on his property. And he thought that this change was directly targeted towards him.
This is the reduction. They're trying to put the reduction from what is currently 10% to 5%.
To 5, yes.
Once again,
I know.
Mine and Apples and Heartspans are the only ones in the entire town that this affects. So I'm not sure why. 2 of them, well, basically 3 of them are farms. I thought we struck this down last time I was here. It goes from 10% to 5%, Peter.
Or 5% on, how many acres do you have?
Total for this new dissolving generator, because I'm trying to put an indoor riding ring on my property. That's 100% why it's getting generated.
This really wasn't directed at you, though, just so you know.
How is it not?
But when the discussions were had, you weren't even in line.
But how is it not? How is it not?
That may be the result, but that wasn't the purpose.
But that wasn't the
what he
purpose.
said.
That begs the question, who was it targeted at? Clearly, it was targeted at me. And he kept bringing it up because Peter Walsh wasn't there for the previous meeting, and he wasn't there for when they voted me down. So he doesn't realize that they were only presenting this and changing the temporary structures and the temporary garages and everything like that just to prevent me from coming in and being able to store cars on the property.
That wasn't the intent at all.
Who brought it up? Who brought it up?
I did. Because we were trying to get people from superseding the ground coverage on their property. That's why it specifically says in here.
But it says, and so if we want to do that, then we just have to follow through to make sure that it's used as agricultural purposes.
Right, but it also specifically says too that this would be on anything less than 2 acres. If you look on item A. And that's really why it came up. So that people had undersized properties.
So it says 2 acres or larger.
Right.
You're telling me that
You'd have
2
to have,
acres is
you'd
small.
have to have a minimum of 2 acres to even, to request, you know, for being able to ask for that relief. That
So
would-
why
that
don't we
would-
put it in? Why don't we just put it in as any?
Because they were talking about the size of the structure. When we thought about how large it was, that's the reason why.
Correct.
But it's been there for 10 years or 15 years. And now it's all of a sudden, right as I have an application in front of the state.
Yeah, but
they're
that's
gonna
not
put
really
it.
what, that's not really what it's been. I mean, and I'm telling you that because I was the one who suggested it, and that's not the reason why I suggested it. And I really didn't think of the backlash on your property, to be perfectly honest with you. And that's why I wanted you included in these talks now, because you are personally involved in it,
Yeah.
you know.
But Pete, where is it talked about? I heard either that meeting or prior to that somehow, of the discussion being for 2 acres and less, that was the reasoning because of other,
Right, because
You know,
people are
things
trying to
that come
circumvent the ground
across.
cover
So
issue.
why aren't we just writing it for lots 2 acres or less? And then that removes anybody who's trying to say, I'm gonna put a barn up on my property when they want to use it for something else. And I understand the intent was somebody gaming the system, but it specifically says buildings exclusively used for farming purposes. So touching that section hits the 2-3 farms on in the town.
The language says you have to be using your barn as agricultural only. So they're like, oh, we don't even have to change the language. But in not having to change the language, they also pointed out that, like, okay, let's just grandfather in all the other barns regardless of what they're used for.
But we'll also grandfather in existing barns for whatever
That's a given.
purposes they
That's a
use
given.
for. Okay.
Well, if the language hasn't changed, now you're saying anyone who's not conforming with the ordinance doesn't have to conform with the ordinance, even though they shouldn't be approved as barns, they shouldn't be barns. But that loophole is now closed only for me, and anyone else who's in violation of that loophole because they gave it to them like that, they don't have to fix it, because we're going to now effectively grandfather in people that were not approved properly to not count this lot coverage as lot coverage because it was a barn when it's not being used for agricultural, when it should have been used for agricultural. It's just the most corrupt thing ever. This is absolutely maddening that it's happening in broad daylight, and they think they're smart enough to be able to, like, slip it through.
and I know that that's what your intent was, if I'm not mistaken. It's been like this for 25 years, at least to help resolve, I don't want to say immediate, for lack of a better word, but what you were looking to do, which I do not disagree with, is the non-conforming lot issue, which now does not allow anyone under the 2 acres to have this as part of their coverage.
Because the other thing says it has to be used for farming purposes.
Yeah, you can't come in and ask for it.
So you can't come in and put a barn and say you're gonna put 10 cars in it.
Yeah, you can't do it.
So what do you propose?
So why don't we keep it in the 2 acres, don't change the 5%, since it's really was an issue about undersized lots, superseding the zoning ordinance.
As a recommendation from the planning.
I'll make that motion. Could I have a second?
Second.
And a roll call. Ted Brack?
Yes.
David Hanson?
Yes.
Steve Gravani?
Yes.
Demetrius Venastanos?
Yes.
Peter Lane, yes. Mayor Schaefer?
Yes.
Paul Van Dyke?
Yes.
Peter Walsh?
Yes.
David Altman?
Yes.
Okay. 2 things accomplished in one night. I'm shocked. Okay.
See what we can do when we get fired up.
Yeah.
So they get fired up, everybody else gets grandfathered in, and that loophole gets closed without me being able to take advantage of it. So that's where we ended up. I don't have 2 acres, I have 1 acre. Both properties that flank me on the south side and the north side are both 2 acres, so I can't buy any additional land to even try to get anywhere close to 2 acres. So pretty much I can't take advantage of this loophole that everybody else has been granted approval for. Nobody's ever been denied when requesting a barn in the borough of Rockley. So yeah. Now that that's taken care of, it's time for them to approve my resolution. This resolution should have been focused on the denial of my proposed house with a 3-car garage. That's what all the testimony that should be in here. That's all the finding of fact. They can list that the application has been revised. They can list that there's been previous versions of the application or the plot plans or the architecturals, but the vote and the substantiation of the planning board's decisions and their decisions are purely to be based in this resolution on the testimony and what was presented and voted on by the planning board. It wasn't. And the resolution was only drafted by the attorney. There were no conversations between the planning board and the borough attorney after they voted me down up until the resolution was presented to them. I know this because you could see how many times the planning board attorney billed me for conversations to and from the chairman of the planning board during my application. After my application, there were none. So the resolution was authored solely by the planning board attorney. How the resolution usually works is the planning board attorney has always circulated the resolution to council for both parties and then also to the planning board in advance so everybody can review it, give their comments. So by the time it gets to the planning board meeting, they can review it, see any final changes, and then adopt it with any minor grammatical errors or anything like that. In this situation, the planning board attorney did not circulate the resolution to council on either party, showed up, and you would think they would need more time to review it. Well, no, they're going to just sign off on whatever Ken Dalecki produced for this one, and here's what we get.
Can I make a motion to approve the Robert Ferretti?
Okay, before we get to that, I took another look at this resolution and I want to add one sentence to it.
This is Robert Ferretti's.
Page 12 of Ferretti. I want to add a subparagraph of one sentence that says, in addition, the applicant is also requesting an oversized 3-car garage 25 feet by 36 feet in dimension.
Okay.
Okay, that's it?
That's it.
Make a motion to approve the resolution with the revisions noted. Would I have a second? Second. And all those in favor say aye. Aye. Any opposed? None heard.
That's a big problem because if you read this resolution, which I'm about to, it's absolutely absurd. And when I say absolutely absurd, it has nothing to do with land use. The way a resolution is structured is it's got the basic summary of what was transpiring, it's got the findings of fact, it's got the planning board's actions, and then the planning board's justifications for their actions. That is how a resolution reads, and it's got the same sort of structure as the meetings where the applicant's information goes first, so the exhibits go first, then the objector's exhibits, then the planning board's exhibits, then the applicant finding of fact, the objector finding of fact, and then the planning board finding of fact if there is any, and then the determinations are rendered. Now, since the planning board decision has to be determined based on the evidence presented and only the evidence presented during the hearings, it's important that all of the evidence presented be listed in the resolution. Well, that's my first problem, is that they don't even list all of the evidence presented that supports my case. They really don't list any of the evidence that I presented that supports my case. They just make it disappear. So we're going to skip right over to page 4 in the resolution. If you look between number 8 and number 11, it's talking about the January 29, 2018 meeting where it's acknowledging that I had a request for a bunch of waivers, but completely ignores the fact that they also held a vote as to whether or not the application was going to proceed as a bulk variance request or a use variance request. That was pretty important at the time, right? It carried over from one meeting in December to the meeting in January, but not important to make it into the finding of fact that even happened. So I'm like, well, let me go back to the transcript so I have something to refer to. You look at the transcript, which is the official record of what transpired in that meeting, and guess what? It wasn't in the transcript either. They skipped over it. And you're like, well, maybe that was a mistake. No, there's other stuff around that, but they skipped over the entire portion where they made a motion and a vote to not count my application as a use variance, but to proceed forward on a bulk variance. Turns out that was intentional. The court reporter, when I reached out to her to find out why there was stuff missing from the transcript, said, this is the only case I can think of where excerpts were ordered and put together in one transcript. I usually would produce the entire transcript. So I asked her if she could produce the full transcript because we have a pending legal matter. She said absolutely. She claimed she was working on it for a couple of weeks and then she just stopped responding to me. Now, this is a court reporter hired by Mr. Dalecki, who's the planning board attorney, who has been through other hearings with him, and it was very suspect that that played out that way. Let's just leave it at that. Let's leave all the circumstantial evidence for you guys to paint your own picture without me accusing anyone of anything, but that's very suspect. So the first thing they're supposed to do is list all the applicant's exhibits. And what they did was list stuff from my architect, but they completely skipped over all of my engineering plans, which is not appropriate. Despite the fact that they were only voting on the final submission as revised, that's what this whole resolution is supposed to be based on. They just got rid of the plot plans altogether. Why? Possibly because they were supportive of the application. They got rid of all the engineering testimony having to do with those plot plans. It's very, very intentional when documents are missing. This is not a planning board attorney who's been here on his first application. He's been here for 53 years. When documents are missing, it's not a mistake, especially when the plot, at the very least, you have the architectural drawings and the plot plans and the applications. They don't even show up in this. Number 19 says the applicant submitted the following into evidence. It goes A1 through A6. Now, what it doesn't have is A7. Now, what was A7, right? Well, I don't remember, Rob. What was A7? A7 was the property list that I submitted into evidence to support the approval of the application, showing that these coverages have been approved on other properties. And that's supportive, that satisfies the negative criteria, showing that this coverage request has been approved on all these other properties is clearly supportive, and it didn't even make the resolution. And then throughout my lawsuit, I'm like, hey, can you show me where A7 is? We don't have an A7. Well, I had to go back to the audio transcript to see, well, did we enter it into evidence? Absolutely.
Can we mark this
Yes.
as an exhibit?
Well, let's have it marked, though.
What's the last one?
I think it was A6.
So this would be A7? With the board's permission, I would mark it on the back as
Yes,
A7 with
sure.
today's date.
Alan Bell moved to mark it as an exhibit, and then all the marked exhibits were moved into evidence during the final meeting.
We had a number of exhibits marked. I believe they were only marked for identification, unless council has any objection.
Do you need those exhibits?
Yeah. Unless council has any objection, we'll move them into evidence. Mr. Bell?
Yes.
Okay.
However, it's not here. That's a problem. Like, they legitimately took something supportive of the application and made it disappear. And it's not, they can't even find the exhibit. The exhibit is nowhere to be found in the borough hall. I've motioned for it in discovery. It is non-existent. They've destroyed the evidence. And they didn't put it in the resolution. It's not even like it's listed in the resolution and they're just missing the exhibit. It's gone. Somebody made it disappear. And that makes a lot of sense when you think about what this resolution is going to read. Also in evidence, you have the objectors. Dr. and Mrs. Paul McCormick submitted the following into evidence: a flash drive containing a PowerPoint presentation of the objectors produced at the March 12, 2018 Planning Board hearing, including all slides and video presentation. The same was marked into evidence 01. Now, this is important to bring up because this evidence, and it was even objected by my attorney, that the evidence put into this file can only be what was shown to the board.
Thumb drives of your PowerPoint presentation, am I correct?
Correct.
And the one that Mr. Dalecki is holding up now, which I'll represent to you that I mailed to him, is that one of the copies that you prepared?
Yes, it is.
And that is intended to be a true copy of the PowerPoint presentation that you showed the board at the public hearing where you testified?
It is.
Thank you. Any objection?
The only concern I have about that, quite frankly, Mr. Pilecki, is that there were interruptions and not all of it was testified to and not all of it was shown. So I don't...
I agree with you as far as Dr. McCormick's presentation from what he was reading from.
Yes.
I know he skipped over things.
Yes.
And that was in my letter to council too, that should not be admitted into evidence because it's not fully accurate. I don't know that that's the case with this, though. I thought that everything
If
went
that's-
through.
If that's purely a video of what was run on the screen, then I have no objection.
Okay.
But as to what your concerns were, they were mine as well, so I trust that that is not included in what you have there.
Okay, Mr. Dell, I guess the question for your client is, does this contain anything other than what was presented on the screen at the March 12th hearing?
No.
Thank you.
Thank you.
He represented, my neighbor, represented that everything on this presentation was submitted in evidence. It's not. He's got, in this, and the only way I would have this is if they submitted it, his notes and stuff like that. So there is improper evidence here in that the stuff that he wasn't allowed to testify to shouldn't be in there, as well as the notes that he has that should not be in there because they weren't showed to the planning board during the application. So that is improper evidence also entered into the resolution and to the planning board file that doesn't belong there. Now, my favorite is what is marked as PB1, and that's under number 21. The planning board submitted the following into evidence, and it was a list of the past undersized lot coverage variances for one-family dwellings from 2002 to 2017 that were addressed by Greg Pliniak in his testimony. The same was marked into evidence as PB1, but it wasn't. Because, as this says, listing of past undersized lot coverage variances for one-family dwellings from 2002 to 2017 was the title of the page, but he got rid of all the variances that were listed. All the variance relief is no longer there. He modified the list, and to substantiate and hide the changes to the list, he called the engineer as a witness to testify as to how many garage bays were on each of the properties.
Okay, Mr. Poliniak, what I've given you, all the board members and council, is a list of the 7 properties without a lot of information that was on my prior listing from last month or the month before, I don't remember. All this is an identification of the property by location, lot and block, street address, and size, nothing else, nothing about variances. I asked you to physically go to these properties and view them, correct?
Correct.
And did you do that?
I did do that.
And when was that done?
March 12th, 2018.
On March 12th, and that means he went after the planning board meeting where my neighbor gave his presentation. It ended at 11 o'clock at night. So assuming they had a conversation after the planning board meeting, what, the engineer from the borough went around with a flashlight like a cat burglar at 1 in the morning or 11:30 at night, like looking at the different garages on these properties? That's absurd, because that is something that can easily be told from the resolutions of approval, or you could look at the previous plot plans, and most importantly, you'd look at the previous as-built surveys for these properties to determine how many garage bays exist on each property. You wouldn't drive by every house and start looking. That's absurd, because that doesn't mean it's the size it's supposed to be. It doesn't mean it's the capacity it's supposed to be. And now you're judging capacity looking by how many doors are there and not judging capacity based off of the square footage, which is how they were treating my application. And forget about the modified list. The evidence for the planning board isn't even cataloged right.
Letter of Gregory Dietrich, Preservation Consulting, September 8th, 2017, PB5. Historic Preservation Commission meeting of October 17th, 2017, PB6. And Historic Preservation Commission minutes of the meeting of November 28th, PB7.
PB7 is actually PB5. PB5 is actually PB6, and PB6 is actually PB7. So these are all wrong to begin with. And the fact that they had 83 days to produce this resolution just shows you that there was no fact checking. They just wanted to shove it in there. So now we get to the finding of fact portion of the resolution. And instead of starting with the applicant's finding of fact, they start with PB7, or what is labeled as PB7, the September 8th, 2017 historic review letter from Gregory Dietrich on my initial application, which was at 22-something% with the garage in the wrong place and everything like that. This letter was in response to that submission. However, the imposing scale and massing of both the dwelling and the garage in relation to their lot are out of proportion and therefore inappropriate. Now, this review letter is completely irrelevant to the current application because they didn't ask Gregory Dietrich to review the revised application to get his opinion. They're just using his opinion on something that was since revised 7 times from 8 months ago, which is completely inappropriate to put as a basis of denial or to justify a denial in the resolution. And the reason I put this review letter in here is because they use this as a basis of denial or a justification of their denial here, but just wait until the next application. So this is we're putting a little Easter egg here for you to see in future episodes. Remember this moment. So now we get into the applicant's finding of fact, and now they have to go through my witnesses and discredit them and try to justify why the testimony that they provided was not supportive of granting me variance approval. Number 26, Joseph A. Bruno, who was my architect, provided testimony to the planning board. The planning board finds, however, that said testimony is not supportive of the applicant's entitlements to the relief requested. So they only focus on my architect's testimony for the original submission and didn't focus on any of the testimony of my architect for the revised application, which is what they should be voting on. And they dismissed all of his testimony as not supportive of the application. Then they decided to skip over all the testimony from my engineers and whether they found it credible or not, or supportive or not, where it relates to side yard setbacks, the shape of the property, the actual zoning stuff that they're supposed to be focused on, the stormwater mitigation, the impact on surrounding properties. All of that was testified by my engineers. Nothing. Didn't even make the resolution. And they skip over and just say, well, we find that you didn't have a planner and that was a major weakness in your case. Now, having a planner is very unusual for somebody who's not changing the use of a property. You have a single-family residential staying a single-family residential. Planning testimony is generally for when you're looking for traffic studies. And look, we're going to be changing the use of the property. There's going to be about 12 cars an hour pulling on and off the property, or right now it's a vacant lot, and we're proposing a 6-family house, and that's going to increase the traffic flow, and we may have to mitigate that. That's where planners come in. Not when the use is the same as what exists. They turn this into a completely different application. Nobody else has to ever bring in a planner. There's a lot of people that have represented themselves and gotten their applications approved without a planner, without an engineer, without an architect, and without an attorney. They just come in and represent themselves. But here, I need a planner, and that's a major weakness. And then it's time for them to focus on my hours and hours of testimony across all these different meetings. However, the only testimony they should be focusing on is on the revised application. I've given up trying to get a larger garage. I've now reduced it to 3 cars. This is the application. That's not what they focused on. Robert Ferretti, the applicant, provided testimony to the planning board. The planning board found, however, that said testimony is not supportive of the applicant's entitlement to the relief requested. Specifically, the applicant testified that the Historic Preservation Commission of the Borough of Rockley, quote, actually approved the plans as is, as far as the look and feel, end quote. In actuality, however, the Historic Preservation Commission of the Borough of Rockley only approved the architectural aspects of the proposed development and took the position that the size as well as the lot coverage is a planning board issue over which the Historic Preservation Commission did not render a determination. The planning board finds that this testimony of the applicant is disingenuous and not reflective of the actual position of the Historic Preservation Commission. Now, if you just look at that, I said that the Historic Commission approved the look and feel of the house. That's what they did. I've stated already that the Historic Commission has nothing to do with the lot coverage or the setbacks. That's the job of the Planning and Zoning Board. There was no disingenuous testimony in that that's what they approved. They approved it for the look and feel. They approved the historical aspects of the house. The next thing they say is the applicant testified that I kept the house as modest as I could. In actuality, the main residence lot coverage variance requested is approximately 2.5 times more than the maximum lot coverage allowed by Rockley zoning ordinances. The requested lot coverage would be non-conforming on a 2-acre lot and would need greater than 2.3 acres to conform to Rockley zoning ordinances. Now, when I was testifying about my house, I was testifying about the house because they throughout the application would focus on the garage and then the house was separate. So when I'm testifying, I kept the house as modest as I could. I'm talking about my 2,073 square foot house, which is a size that has been approved on even the smallest of properties 6 times smaller than mine in the town. So the house is as modest as I could possibly do, because to put a house up that they've already determined is appropriate on a lot 1/6 of the size of mine, on an acre of property, is a very modest house. And again, I'm going to point out that no other property has ever been looked at as to how large of a lot would be needed to justify or deny a variance request. They say the applicant acknowledged that when he purchased the property, he knew that he was purchasing an undersized lot and that variances would be required to allow him to develop the property as he contemplated. Accordingly, the applicant was aware that he would not be entitled to develop the property as of right as he desired. It's correct, but I also assume that anyone else would be in the same position, so looking at what's been approved on other properties to determine what would be appropriate on mine was a fair way to go. Apparently that's not true, because I had no idea that they weren't going to afford me the same relief that's been granted to everybody else. The applicant testified that he does not operate any business venture or any part thereof out of his present residence at 174 Pine Tree Lane, Tappan, New York. However, the planning board determined that based upon evidence and testimony presented, that this is not an accurate representation. Never gotten a ticket for commercial use of my property. I've never been accused of commercial use of my property in Tappan, New York. They're making a legal determination that there is commercial use of a property, not stating whether or not it's allowed, not allowed. I said I was not running a business out of my house. They made the determination that I was running a business out of a different house that I was living in a completely different state. This is how ridiculous this is getting. The applicant testified that he does not engage in any commercial enterprises at the subject property. However, evidence produced by the objectors indicate that commercial enterprises are already being performed on the subject property. Now, what would the appropriate remedy be? If they were determining that I was doing commercial enterprises on a residential property, regardless of the development, you would issue me a ticket, right? Send the code official out. He's doing commercial enterprises. Let me go to court. That's due process. I was not afforded due process at any point in time through this process. The testimony of the applicant that no commercial activities are being performed at the subject real estate. However, based upon the evidence presented by the objectors, which the planning board accepts as credible, commercial activities are already being performed at the subject property in contravention of the zoning ordinances of the Borough of Rockley. The applicant maintained a commercial enterprise in the city of Englewood, New Jersey until March of 2017, at which time he was evicted. Based upon the evidence and testimony presented to the planning board has determined that at least a partial of the commercial activities conducted in the applicant's facility in Englewood, New Jersey have now already been transferred to Rockley, New Jersey at the subject property. Now, this is funny because they're making these determinations that because I wasn't engaging with them, I still own Gotham Dream Cars. I had a deal with Beverly Hills Rental Car. They fired me because they owed me money. That was something that was completely irrelevant to this application. So my personal cars and my personal stuff moved out of the Gotham warehouse, but Gotham still operated out of the warehouse. And I still own the business. But they're making these determinations based off of my neighbor's slideshow, which he has no idea what the hell he's talking about, and it's got no business in this application. None of this has anything to do with land use. This just shows you how ridiculous this is that they're trying to enforce me not being able to make videos on my property by denying me the application for building a house and a garage on the property. This is almost as if somebody on the planning board wrote it and then they just signed it through. The planning board attorney drafted this, which is absurd to me. The applicant confirmed that an employee of one of the applicant's commercial enterprises currently resides at the subject premises. The planning board has determined, based upon evidence and testimony submitted, that the applicant is conducting commercial enterprises at the subject property. This is because Jimbo is staying at my house. Jimbo has his own business. Jimbo was an independent contractor that filmed for me from time to time while running his own YouTube channel. He lived at the house until I knocked it down. These determinations of the planning board are like giving me a headache right now just filming this. I was so incensed when I was reading this. It still, 7 years later, still drives me mad. The applicant testified, which, however, the planning board accepted that he has already made videos on the subject property that have resulted in the applicant's receipt of financial benefits, which the planning board determined is activity of a commercial nature in contravention of the zoning ordinances of the Borough of Rockley. That's not the job of the planning board. It's not the job of the planning board to make a determination whether an activity is commercial or not. The applicant further testified that the vehicles he proposed to store on the subject property are used in or connected with videos that he makes and receives remuneration for, thus making the same a commercial enterprise. The result is that if the applicant uses vehicles proposed to be stored or are actually currently stored in the subject premises in the commercial enterprise, the property actually becomes a commercial property in contravention of the zoning ordinances of the Borough of Rockley. So the fact that cars that I own as personal cars have appeared in videos at some point in time, as soon as they appear in the video, now a commercial car, right? The applicant testified that the motor vehicles proposed to be stored in the subject property are his personal vehicles, not commercially used vehicles. However, the evidence and testimony presented refutes that allegation and reflects that the storage of at least some of the vehicles is consistent with a commercial enterprise. They're making the determination that my personal cars are no longer my personal cars. That's not a determination for the planning board to make. The applicant testified that none of his vehicles proposed to be housed on the subject property will be used for commercial purposes. However, one or more of said vehicles have been determined by proofs adduced by the objectors that the same are actually used for commercial purposes. They looked at the picture of my Corvette with the Super Speeders banner on the windshield from 10 years prior and said that makes it commercial. Like, this is a zoning and planning board, by the way, guys. I'm going to keep reminding you of that. This is a zoning and planning board making these determinations as findings of fact. The applicant is requesting lot coverage variance for all buildings and structures of 1,036 square feet in excess of the lot coverage permitted for a 2-acre lot. The coverage allowed for a 2-acre lot is 4,356 square feet. The applicant is requesting a total lot coverage for all buildings and structures of 5,292 square feet or 1,036 square feet in excess of that permitted on a 2-acre lot, which is in excess of 2 times the size of the lot of the applicant. Now, this one I love because if you look at it, I wasn't proposing 5,292 square feet. I amended my application to a 3-car garage, so I was really asking for what would be 300 or 400 square feet more than what would be allowed on a 2-acre lot, which, by the way, is not how you look at variance relief. Nobody else has looked at what their variance request would look like in compared to a 2-acre lot. I'm the only person that they've ever looked at the application this way. Applying the same ordinances that I was under at the time, you have a property that was similarly sized to mine get approved for 5,640 square feet on a smaller piece of property with no special circumstances back in 2002. Another property more recently, another planning board member, got approved for 4,987 square feet, and this is on 0.49 acres. So now they're denying me for less coverage than these other properties have been approved for on smaller properties. In addition, the applicant is also requesting an oversized 3-car garage, 25 feet by 36 feet in dimension. My garage cannot fit anything more than 3 cars, but here they call it an oversized garage. Other people get approved for a garage that can fit 6 cars, that's just a 3-car garage. A garage that's 3 times the size of this, 3-car garage. A garage with 2 doors, double deep, 2-car garage. Nobody has ever had their garage called an oversized garage. So when I reduced my garage to fit no more than 3 cars, got rid of the ceiling, can't even put lifts in it, it can only fit 3 cars, they still consider it an oversized 3-car garage. Then they try to pad their denial by saying the applicant testified, however, that it is possible for him to build a smaller home. Nobody else has ever been held to that standard. Could it have been made smaller? Right? Because every single house that has received variance relief in this town could have been smaller. Every single one of them. But nobody else has been held to that standard. Just me. So instead of focusing on any testimony from any of my experts or myself having to do with the positive and negative criteria being satisfied, all they focused on was questions from the objecting attorney about what I do for a living and my testimony as to whether I made videos on the property or where my cars are registered. It's absolutely absurd that they're supposed to weigh the evidence, and only the evidence on this modified application, which there was no testimony from the objectors or anything like that about anything other than the garage capacity on the revised application. And they bring in all this other testimony having to do with a 12-car garage and what my intended use of the property is, when my intended use of the property was always stated that I just want to have a single-family residential. It's absolutely maddening that they took the 3 or 4 videos that I posted inside a year of buying the property and turned my entire property into a commercial enterprise. Now here we go to number 34. Objectors Dr. and Mrs. Paul McCormick own and reside at 3 Willow Avenue, Rockledge, New Jersey, which is a property that abuts the applicant's property on the eastern and southern sides of the applicant's property. Dr. and Mrs. McCormick also own 34 Piermont Road, Rockledge, New Jersey, which abuts the applicant's property on the southern side. Now this one I love, because they're saying that anything I touch, if it's registered in Montana or registered to a company, is commercial. The McCormicks don't own the property next to me. They put it in an LLC in their kids' names. So their kids aren't even represented here. So they're representing a property that's owned, even though they may have paid for it, it's not owned by them. It's owned by their kids. And their kids were not, they did not state representation. The attorney did not state that he was representing the children. They did not state that they were representing the LLC that owns the property. They claimed, and mistakenly claimed, that they owned both. And now, look, objectively, do I know who's on the LLC paperwork? No. But he testified that it was under the names of their kids, which is a common thing for rich people to do, is put stuff under LLC to pass it around for generations. It's nonsense, but if you're going to go so strict with like, well, that's commercial because it's under an LLC, so is the property next to me then. Then number 35, the objectors, Dr. and Mrs. Paul McCormick, provided the following testimony and evidence to the planning board, which the planning board finds credible and accepts. So all of the stuff that I proposed is all made up and fictitious, but everything that the neighbor came up with, they find credible and accepts. And what I love about this, the objectors, Dr. and Mrs. Paul McCormick, Mrs. McCormick didn't say a word. She never testified a thing. Only he did. He grabbed the microphone. She did not. So to say that she made any testimony is fictitious and wrong. Now, the stuff that they allowed into testimony and found as a finding of fact. Remember, this is finding of fact, not that he testified to this. This is the finding of fact. Dr. McCormick advised the planning board that he and his wife objected to the variances requested as to the extent and magnitude of the variances requested, in so much so that there are multiple, not percentages or increments, of the maximum allowed by current Rockledge zoning ordinances. In addition, the objector testified that the use to which the applicant intends to put the property is not only not zoned for, but is prohibited by the provisions of the Rockledge zoning ordinances in the Rockledge National Historic District. Now, let's remember, I did not propose to use the property for anything other than single-family residential. I testified that if the use of the property, filming or anything like that, I'm not proposing that. If it's not permitted, I won't do it. That was my testimony.
It's part of the application, and you order your testimony, and it's your intent that there will be no business run from the property, and that none of your commercial vehicles will be stored on the property.
Correct.
So not only was I not seeking a use variance, I consistently testified that I had no intention of doing a use on the property that wasn't allowed by ordinance. And now that my application was revised to limit the capacity of the garage, all they could do is use testimony and focus on the old application and not the revised application as a basis to deny me. The residence proposed by the applicant is 2.5 times more than the maximum coverage allowed by the Rockledge zoning ordinances. Coverage would not be conforming on a 2-acre lot, which is the minimum size for a residential lot permitted under the Rockledge zoning ordinances. The lot coverage proposed would need greater than 2.3 acres to conform to the Rockledge zoning ordinances. The applicant's property is slightly less than an acre. Now remember, that was a previous version of what was submitted during this. The resolution and the vote was not on what was previously submitted. The resolution and the vote can only be testimony related to what was ultimately submitted to the board, the revised application for a 3-car garage, and the house. I want to point out that on this revised application, both the objector and his attorney had the ability to testify against the revised application. They did, and that's the testimony that should be cited here and not stuff on the original submission, because that's no longer relevant now that the application has been revised. And then I love this one. The applicant's proposed main residence is 350 square feet larger than the objector's main residence located on a 5-acre parcel of 3 Willow Avenue. This is where he was claiming that my house is bigger than his house. Now, if you look at an aerial map, clearly it's not. And that is with him taking the house and the garage and combining the two with the underground tunnel. My main structure is a fraction of the size of his house. It's so to talk about disingenuous testimony, that's ridiculous. Like, my house is a fraction of the size. His house is 4,230 square feet. Mine, when I revised it down, was 4,086 square feet. And that's including the tunnel, the house, and the garage and everything like that, and the porches. It's absurd to compare the two. It's absurd, and it's insulting to say that my above ground house is anything near the size of his house in a 5-acre property. If there was ever a red herring, you're looking at it. Notwithstanding the applicant's testimony that he does not use his current residence in Tappan, New York for commercial purposes, Dr. McCormick exhibited a video posted by the applicant on the internet, filmed at his Tappan property, showing commercial use of his property. So we'll just keep this going here. A further video submitted by Dr. McCormick reflected the applicant himself telling one of his employees not to make excessive noise on the property because he did not want to do anything to jeopardize his application before the Rockley Planning Board. The Planning Board determined that the clear application of this comment was that once the relief was granted, he would do whatever he wanted on the property. That shows you the mindset that they have when denying me here. It's got nothing to do with zoning. The other videos produced by Dr. McCormick reflected and corroborated that the very nature of the applicant's business is based in part upon complete disregard of traffic laws. Great. Further video slide presentations of Dr. McCormick reflected that the applicant is using the same Florida license plate on numerous vehicles within an extremely short period of time. Great. In another video posted by the applicant on the internet, the applicant boasted that the rules of the road do not apply to him. Great. You know what's funny about that too? There was never a video. That was just the tagline for my website back in the day. So that statement is false anyway, because it's just they read it off the website that the rules of the road don't apply. It's absolutely mind-boggling what a witch hunt this was. I'm going to skip through some of these. Dr. McCormick further provided the video of the applicant himself posted on the internet that he will say whatever he has to say in order to obtain his required approvals from the planning board, with the obvious implication that thereafter the applicant has no intention of abiding by the rules and regulations applicable to him, his property, and the use of his property. This is in the resolution. Dr. McCormick further provided the video reflecting that a third party is already using the subject property on the internet, Jimbo's channel, for commercial purposes. Dr. McCormick provided further video depicting the applicants using his current Tappan property as a showroom for the sale of one of his production cars, as well as filming videos at night at his current location featuring his cars, sometimes revving their loud engines in a residential neighborhood. Dr. McCormick further provided video placed on the internet by the applicant where the applicant encourages another individual to rev up his Corvette. Show me that video. This is a video that doesn't exist, and it's mind-boggling. And also, it's not illegal to say rev up your car, even if that video did exist. I can say rev up your car on my property during the day. If I'm doing something illegal, you call the cops. The purpose of this was to deny me based on the fact that they were afraid of me and they didn't want me there. And it had nothing to do with land use. It's the most ridiculous thing and the most egregious thing I've ever been a part of in my life. And it's all because it was drafted by the planning board attorney who is still to this day fighting this case for the borough. And if that's not a conflict, I don't know what is. Then they go through the list of properties put forth as PB1, which is the list of the 7 properties, and the garage capacity. That's irrelevant because it doesn't matter, but it does show that they modified their previous list that used to have all the variances approved on the same properties. They modified that list to then make that disappear and now continue to enter that list into evidence with the missing information, because that evidence would have supported the approval of this application. Instead, now it's taking the same 7 properties and saying, look, they don't have a lot of garages, and this guy's looking for a 3-car garage, so we shouldn't be granting it to him. Planning board member Robert Schaefer was sworn by the court reporter and provided the following testimony. Great, he shouldn't be testifying and voting on the application. Further findings of fact. Number 38, the planning board determined all variance approvals for the last 9 years reflected that the applicant's proposal is larger than the house approved without a variance on a 2-acre lot. That's A, incorrect and also easy to prove. In addition, for 3 homes on lots 1/2 acre or less being virtually identical in size to the applicant's property to which variances were approved, all of the lot coverage variances were significantly smaller than that proposed by the applicant. First off, my lot is 1 acre, not 1/2 acre. 1/2 acre is 50% of the size of my lot. And the lot coverages that have been approved on all those other lots exceed what I've been denied for. That statement is also fictitious. This is in the finding of fact. I get so worked up about this, and I'm sorry I'm being animated, but this is absurd. The planning board has evaluated the impact of the proposed development, including the variances requested by the applicant, upon the adjacent properties, the general neighborhood of the borough of Rockley, and the borough of Rockley as a whole, including but not limited to the historic district within which the applicant's property is located, and has made the determination that the proposed development would cause such damage to the character of the neighborhood as to constitute a substantial detriment to the public good. The size of the proposed development in relation to the size of the property upon which the proposed development is to be constructed, along with other findings of fact as set forth herein, leads the planning board to the determination that the proposed development will in fact cause substantial damage to the character of the neighborhood and constitute substantial detriment to the public good. The planning board has to articulate what that detriment would be. They just say it's going to be a detriment to the zone without articulating it. And the only articulation you can make is that I would be living there. And that's the only negative impact it would have on the zone. Because even trying to claim that the house is too big, it's not visible above grade. It's an imaginary detriment by saying this house is so big when you can't even see it above grade. Nobody would know that there was a tunnel connecting the house to the garage. It's a made-up detriment and they can't substantiate it, which is why they dance around it and make it claim like I'm looking to change the use of the property when I wasn't looking to do that at any point in time, and I never testified that I wanted to. The Borough of Rockley, through Ordinance Section 34-23.6 of the Rockley Zoning Code, limits the aggregate ground area of all buildings and structures in any lot in the A zone, the zone within which the subject property is located, to 5%. The property, the subject of the within application, is seeking lot coverage variance for all buildings and structures of 11.6% or in excess of 2 times the maximum aggregate ground area for all buildings and structures permitted. In addition, the aggregate ground area for all buildings and structures requested by the applicant even exceeds the aggregate ground area for all buildings and structures permitted for a conforming 2-acre lot. The applicant is seeking maximum aggregate ground area coverage of all buildings and structures for a 2.3 acre in size lot, well in excess of 2 times the current size of the applicant's lot. All right, first off, they're still using the original submission and the size of the original structures proposed as a basis of denial in this resolution when the application has been modified. So this makes no sense, and I'm still the only person that they've ever compared what the lot coverage requested was to what it would look like on a conforming lot. It makes no sense. While the planning board acknowledges in certain instances, for certain applications, the planning board has granted such relief, in this particular instance, for the subject property and for the use to which the subject property is proposed, the planning board finds that it is inappropriate and will substantially impair the intent and purpose of the zoning plan and zoning ordinance. Now, here is where they should provide a clear distinction as to what makes my property different than the other properties that they've granted 11% or greater lot coverage on. Because if it was, we've granted 11% lot coverage in the past, but all of those properties were predominantly retaining walls and built into the hills. Sure, that's a valid argument. Or we've granted 11% lot coverage in the past, but that's only been on lots that are 1/4 of an acre or smaller. They can't, because they've granted 11% lot coverage on conforming lots, on oversized lots, and even on the largest lot in the town. So there's no justification and no rational basis to deny me 11% when it's been granted to everybody else. The applicant has not shown the hardship required by NJSA 4055D to entitle him to the variances requested for lot coverage for the principal building and the lot coverage for all buildings and structures. In addition, the applicant has not shown the proofs necessary to entitle him to relief pursuant to a C2, as the proofs have been submitted that the purposes of the municipal land use law would be advanced by a deviation from the zoning ordinance requirements, and the benefits of the deviation would substantially outweigh any detriment. Covered that in the last video. I provided the positive and negative criteria, and then I also provided the proofs necessary for the C1 hardship. So we've covered them both. They were both there. They just didn't end up in the resolution because they got rid of the evidence. The applicant's proposal to increase the aggregate ground coverage of all buildings and structures to 11.6%, taking into consideration the proposed use of the subject property, fails to assure physical compatibility within the historic district within which the property is located. But on all the other properties, it did. Just remember that. The applicant has not provided the planning board with the evidence and testimony necessary to meet its burden of proof to entitle him to the relief requested. Therefore, an appropriate determination to deny the relief is requested. And now here's where it gets good, right? Because there's something called the Open Public Meetings Act, which require any determinations to be listed in the resolution, and also all deliberations to be public, so they can be contested by the public, just so there's no backdoor dealings and stuff like that. That's called the Sunshine Law in New Jersey, and it's to instill confidence in the government, which this clearly does the opposite. Number 45 states, the planning board has determined that the application should be denied based upon two separate and distinct approaches, both of which, independent of each other, are sufficient to support the planning board's denial of the applicant's applications. The first approach is based upon the factual determinations of the planning board that the applicant has not provided the planning board with the evidence or testimony necessary to meet the burdens of proof to entitle the applicant to the relief requested for bulk variances requested by the applicant for the lot coverage variance for the primary residence and for the lot coverage variance for the ground area of all buildings and structures. But I did produce the proofs necessary. They just chose to ignore and destroy them and not enter them into the resolution. And I like the fact that they highlight the word necessary, because they're right. There are necessary proofs required for variance relief, which should mean all other applications before the board should have produced those proofs as well to get variances approved, and yet they didn't. In addition to the above, the planning board has determined that a second and separate basis for its decision to deny the applicant the relief requested is what the planning board considers will be the applicant's proposed use of the subject property for commercial purposes. The planning board determines that the proposed use of the property will be, at least in part, for commercial purposes in a residential zone, which commercial purposes are prohibited by the zoning ordinances of the Borough of Rockley. The proof set forth by both the applicant and the objectors indicate that it is the intent of the applicant to use the property for both residential and commercial purposes, notwithstanding that at the request of the planning board, the applicant noticed for bulk variances as well as a special reasons variance. The application of the applicant does not indicate a request for a special reasons variance. Again, this completely ignores the vote before the application was heard, that they knew what I did. There was testimony from all sides. They deliberated over 2 months, and they decided that we were not going to proceed and didn't need a use variance due to the size of the garage. And even so, the garage was reduced to 3 cars, so now it removes the use variance from it and the variance for the capacity of the garage. So there is zero justification to claim that the use of the house is now changed just because I'm living there and because I have a YouTube channel. It would be just as ridiculous to say I was looking to build a 19,000 square foot house on the property, despite the fact that the application wasn't asking for a 19,000 square foot house. That's the equivalent of voting me down and saying I'm looking for a use variance when there is nothing on the record of me asking for a use variance. Again, based upon the proof submitted by the objectors and the applicant, as well as the lack of proof submitted by the applicant, the planning board determines that there are 2 separate and distinct bases for the denial of the applicant's applications as set forth within. Now, this one I love because the vote by the planning board was this.
I'm going to make a motion that we deny it. I don't think there was significant hardship. I think the ground area coverage is 9.9% is way more than anything that's been brought from the board since I've been a member. we're going to have other applications coming in shortly, and we're going to be confronted with this issue again, and if we give into this now, it's just going to make it more difficult. I think the applicant could have made an effort to purchase property, either going north or south. I think both of those parcels are over 2 acres, and maybe could have attained more property. I think the applicant was aware of the zoning when he purchased the property, and I think the coverage could easily be reduced further if they tried.
Then you get this resolution. The findings of fact are fictitious. Half of them are made up. Half of them are inaccurate. There is evidence that was missing. There was evidence that was modified and then entered as evidence. There was incorrect evidence entered. They're comparing my property to 2-acre lots where they've never done that to anyone else. They've come up with a second separate basis of denial. They're denying me based off of use when I wasn't looking for a use. That is all enforcement. If they want to come after me for the use of the property, if I'm testifying I'm not going to use something commercially, effectively they're saying, well, we think you are. And they're denying me based off of the presumed intent of the use of the property. You can't do that. That's not how the world works. And here they just made it up. The fact that they came up with a second separate basis of denial when they didn't vote on it, they didn't propose it, they didn't make a motion, they can't just add other bases of denial into an application when there was no motion. They've done that and done so without any public discussion, without any input from either council. I've never read a document that's made me more angry in my life than this resolution of denial. Yet the funniest part about all of this is that I wouldn't be here. They wouldn't be in this position if they would have just settled this out before I filed this lawsuit or shortly thereafter. Instead, they're relying on Ken Dalecki, and I'm sure half of these people haven't even read these documents before signing them. They're just refusing to acknowledge that they screwed up. And if I haven't proven that by now, just wait. And wait, you're going to have to. As I'm editing this, I realize it's already over an hour just for the resolution. So I'm going to make what they did for themselves a completely separate episode, or at least a part 2 of this episode, just to stay on the wireframe I initially put together. But I don't want to run this into like an hour-and-a-half long episode. I want you guys to be able to really take in what I'm providing and all the information I'm providing. And what they've given themselves is quite ridiculous compared to how they treated me, and I will turn that around in the next couple of days. So there'll be like a 2 or 3 day difference between the uploads. Thank you for watching. Rob Ferretti. I appreciate anyone who's made it this far in the video, anyone who's invested in this series and watching along, and all the attorneys and other professionals and just individuals that have reached out around these applications and around the treatment to maybe pick up something that I may have missed. You guys are all awesome. Thank you for watching, and I'll see you soon.